Hello and welcome to TaxPundit.org. TaxPundit is India's most popular and trusted database of income tax case laws. In today's video, we will be analyzing a landmark case study that provides critical insights for tax professionals. Let's dive right into the details. The case under discussion is Shailendra Nath Rai vs. Assistant Commissioner of Income Tax, pronounced by Delhi High Court on the 29th of May 2026. On 29th March 2024, the AO issued a notice under Section 148A(b), granting time to file reply until 8 April 2024. On 8 April, the petitioner sought adjournment. The AO issued a fresh notice granting time until 12 April. On 12 April, the petitioner again sought adjournment. On 21st April, the petitioner filed a reply contending proceedings were time-barred. On 30th April, the AO passed the order under Section 148A(d) and issued a notice under Section 148. For assessment year 2017-18, the normal limitation period for issuing a Section 148 notice expired on 31st March 2024 under the first Proviso to Section 149(1). The Revenue argued that, in light of the Delhi High Court's decision in BKR Capital Private Limited vs. Income Tax Officer, the proceedings were valid. The petitioner distinguished BKR Capital on facts. The petitioner contended that the reassessment proceedings were time-barred because the AO failed to comply with the extended time limit under the 6th Proviso to Section 149. The order under Section 148A(d) and the Section 148 notice were issued on 30th April 2024, which was beyond the permissible 7-day window from the date of receipt of the reply on 21st April 2024. The Revenue argued that the proceedings were saved by the mere fact that the initial notice under Section 148A(b) was issued before 31st March 2024, the original limitation expiry. They relied on the Delhi High Court decision in BKR Capital Private Limited to support the validity of the reassessment. The High Court's reasoning is anchored in a precise parsing of the 5th and 6th Provisos to Section 149. The court acknowledged that issuing the Section 148A(b) notice on 29 March 2024 with a 7-day deadline appeared problematic because the limitation period would expire on 31 March 2024, leaving only 2 days. However, the court clarified that the mere issuance of a notice within 2 days of the limitation end date does not per se vitiate the proceedings. The 5th Proviso to Section 149(1) states that the time allowed to the assessee for filing a reply under Section 148A(b) shall be excluded from the limitation period. In this case, the period from 29 March 2024, date of notice, to 21 April 2024, date of reply, a total of 24 days, was excluded. After exclusion, the remaining limitation period, which had expired on 31 March 2024, becomes a negative figure. The 6th Proviso then comes into play. It provides that if, after such exclusion, the remaining period of limitation is less than 7 days, the limitation period shall be deemed to be extended to 7 days from the date of receipt of the assessee's reply. Therefore, the AO had until 28 April 2024, 21 April 2024 plus 7 days, to pass the order under Section 148A(d) and issue the Section 148 notice. The AO passed the order and issued the notice on 30 April 2024, 2 days beyond the extended deadline of 28 April 2024. The court held that this delay rendered the entire reassessment proceeding time-barred. The Revenue's argument that the proceedings were saved by the mere fact that the initial notice was issued before 31 March 2024 was rejected. In BKR Capital, the Section 148A(b) notice was issued on 21 March 2024, with a reply deadline of 28 March 2024. After adjournments, the AO still acted within 7 days from the final reply. The crucial difference was that in BKR Capital, when the initial notice was issued, the AO had a realistic window to complete the process before the original limitation expiry, even without invoking the sixth proviso. The Revenue cited Raminder Singh versus Assistant Commissioner of Income Tax. The court observed that Raminder Singh dealt with a different context and did not involve the specific interplay of the fifth and sixth provisos. The facts of Shailendra Nath Rai were squarely governed by the newly inserted provisos under the Finance Act, 2021, which the revenue could not overcome. The court further held that merely because the AO initially allowed 7 days, which extended beyond 31st March 2024, did not make the notice void. The Parliament intended to grant a minimum of 7 days opportunity to the assessee, and the AO's initial grant of time was lawful. However, once the reply was filed, the clock started running from that date under the sixth proviso, not from the original notice date. The Delhi High Court allowed the writ petition, quashing the order dated 30th April 2024 under Section 148A, D, and the consequent Section 148 notice. The judgment reinforces that in reassessment proceedings, the AO must not only initiate action within the original limitation period but also comply strictly with the extended time limits provided in the fifth and sixth provisos. Question: what is the significance of the fifth proviso to Section 149 in this case? Answer: the fifth proviso excludes the time allowed to the assessee for filing a reply under Section 148A, B, from the limitation period. In this case, the period from 29 March 2024 to 21 April 2024 was excluded, meaning that the original expiry date, 31 March 2024, is not the cutoff for the entire process. Question: how does the sixth proviso to Section 149 operate? Answer: the sixth proviso extends the limitation period to 7 days from the date of receipt of the assessee's reply if, after exclusion under the fifth proviso, the remaining period is less than 7 days. The AO must complete the order under Section 148A, D, and issue the Section 148 notice within those 7 days. Question: why was the case of BKR Capital Private Limited distinguished? Answer: in BKR Capital, the AO issued the Section 148A, B, notice on 21 March 2024, well before the limitation expiry, and acted within 7 days of the final reply. In the present case, the AO issued the notice on 29 March 2024, 2 days before expiry, and delayed beyond the 7th day from the reply, making the facts materially different. Question: can the AO grant multiple adjournments without affecting limitation? Answer: yes, because the time taken for the entire process from notice to receipt of reply, including adjournments, is excluded under the fifth proviso. However, once the reply is received, the sixth proviso imposes a non-negotiable 7-day deadline for the AO to pass the final order. Question: what is the practical takeaway for taxpayers? Answer: taxpayers should file their reply promptly to ensure the 7-day window under the sixth proviso starts ticking. If the AO delays beyond 7 days from the reply date, the taxpayer can challenge the reassessment as time barred, as successfully done in this case. Thanks for watching this video. You can download the full legal analysis, the official case law, and a concise case digest PDF directly from our website, TaxPundit.org. If you have any questions, feel free to write to us at TaxPundit@TaxPundit.org, or message us on WhatsApp at 9326306668. Don't forget to subscribe to our channel for more authoritative legal updates.